Welcome to the sixth lecture in the 2014 Workplace Relations Education Series. The series has featured mock hearings and lectures delivered in conjunction and collaboration with a range of universities and associations around the country, as well as an invited paper series which we launched earlier this year. Today's lecture is, as you've heard from Anna, being held in collaboration with the Centre for Employment and Labour Relations Law at the Melbourne Law School, and will be delivered by Professor Andrew Stewart and Dr. Meg Smith. Andrew and Meg will be well known to many of you. Andrew is a John Bray Professor of Law at the University of Adelaide and a consultant to the national law firm Piper Alderman. He's also President of the Australian Labour Law Association and an editor of the Australian Journal of Labour Law. Among his many publications include Crichton and Stewart's Labour Law and Stewart's Guide to Employment Law. Meg is the Director of Academic Programs, Human Resource Management and Industrial Relations at the University of Western Sydney. Meg's academic work has recently focused on contrasting and complementary approaches to gender equity evaluation and regulation, including equal rights discourse in industrial and discrimination-based legislation. Today, Andrew and Meg will speak to us about the development of equal remuneration regulation and gender pay gap problems that regulation seeks to remedy. They will also forecast some of the future challenges for the Commission when deciding equal remuneration cases. I always look forward to yet another future challenge facing the Commission, and I wait to hear what they say about that with interest. Before I hand over to Andrew and Meg, I'd like to extend my appreciation to the staff at the Centre, particularly to Anna Chapman and John Howie, for their support for the lecture series this year, and importantly to the Centre Coordinator, Tessa Dermody. Their dedication in facilitating this level of public interest in workplace relations issues has been a key to the success of the series, and I'd like to thank them as this will be the last occasion that will be here this year. I now welcome Andrew and Meg to the podium to address us.
Thank you, Justice Ross, and thank you to the University of Melbourne and to the Fair Work Commission for the invitation to speak with you today. Something of an outline. We will initially, foreground our examination of pay equity regulation by highlighting some key pay equity indicators. We're going to draw some attention to material in our 2013 research report and provide a snapshot of the Equal Remuneration regulatory outline that preceded the Fair Work Act. In this respect, we note that the current day developments invite an explanation of what occurred in the past, albeit briefly. Andrew is going to address the equal remuneration provisions in the Fair Work Act and their key consideration and application in the SACS proceedings. And as Justice Ross has indicated, we are then going to highlight a number of the uncertainties that confront equal remuneration regulation and consider a number of the choices that confront the Commission, both in current and future proceedings. And we hope that there'll be time for questions. So just a starting point, part of the key interest in gender pay equity arises from the persistent nature of the gender pay gap. And there is clear evidence of ongoing gender pay inequity, notwithstanding that there are a number of measures that we can utilise to examine this phenomenon. And of course those measures vary if one is using ordinary time or total earnings or the inclusion of managerial earnings and the like. But based on this particular measure, which is full-time adult ordinary time earnings over a 20-year period, May 1994 to 2014, we note the persistent nature of the gap, 15.7 to 18.2% on this particular measure, and its resilience to reform over time. Now, of course, these is an unadjusted earnings data, but even with adjusted earnings data, as featured significantly in both our report, which we will come to shortly, the evidence there indicates a significant, persistent, unexplained gap between women and men, and these findings cannot be explained by productivity-related differences between women and men, notwithstanding the frailties of the human capital critique, and such as differences in education and workplace experience. So contributing factors to that unexplained gap include the undervaluation of feminised work and skills, differences in the types of jobs held by men and women, and the method of setting pay for those jobs and structures and workplace practices that restrict the employment of workers with family responsibilities. Just seeing this with an international lens, we can see there that I guess one of the interesting features in trying to pull together international data is that it's hard to get a consistent sort of data set. This is OECD data, and which in a data sense works on a median average as opposed to a mean average. So there's some differences with the ABS data previously presented. All data here is not from the same time frame, so there's data here ranging from 2010 to 2012. But as presented here, the wage gap in Australia is 13.8% as opposed, that's I guess a little improved to the OECD average, which is 15.3%. Now, much of the work that we present today arises from the research report completed for the Fair Work Commission along with Robin Layton. And that was a report that was commissioned in July 2013. And the explicit terms for that report was that it would assist parties to equal remuneration proceedings under Part 2.7 to engage in productive discussion and work towards greater consensus in relation to proceedings and inform potential parties about the matters that might be required to address and the type of evidence they might be required to bring to those proceedings. And so those broad instructions invited us to consider a number of factors, and that was a discussion of Part 2.7 itself, and Andrew will report on that this afternoon. An overview of matters and an application for equal remuneration may need to address in order to satisfy the requirements of Part 2.7. An overview and discussion of supporting information, which invited a great deal of material as to the contributing factors to the gender pay gap and also approaches both domestically and internationally. And a discussion of the materials previously mentioned and their impact of how we might consider the questions raised by Part 2.7 in the Fair Work Act. The report includes a great deal of international material which we don't canvass here today, and highlights a number of disparate approaches to equal remuneration regulation, but noting as well that the ILO Convention provides that nation states hold responsibility for the way in which they implement the convention. So just a brief snapshot prior to getting to Part 2.7. And we date our analysis from 1969 and the 1969-72 principles, noting that both shared a close proximity to Australia's then wage fixing system. Now, the key impetus, of course, for the 1972 proceedings, and including the larger principle of equal pay for work at equal value, of course, was the limitations with the 1969 principle and its limitation to areas where women were performing the same work as men, and its exclusion of areas where the work was undertaken predominantly by women. The introduction of the concept of equal value vexed then, as it continues to be, became very much a live issue in 1986 in the comparable worth proceedings, where the Commission rejected the use of comparable worth as a means of applying the 1972 principle, but reaffirmed the continued availability of work of the 1972 principle and the concept of work value as traditionally utilised by the Commission. So this sort of sense of troubling issues in the assessment of equal value dates from a significant period, but we can perhaps have some carbon dating specifically from the 1972 principle. Now, the hiatus in pay equity reform that was inspired by, but not confined to, this sort of assessment of equal pay for work of equal value helps to explain, for us at least, the introduction of the equal remuneration legislative provisions in 1993 into the Industrial Relations Act via the Reform Act. And key to a number of challenges in those provisions, most notably evident in the HPM proceedings, but certainly not confined to those proceedings, was a requirement that applicants demonstrate a sex-based discrimination cause for any earnings disparities. And so the use of the term without discrimination as within those provisions was interpreted by the Commission to require that applicants effectively meet a discrimination test. Now, these provisions were retained by the Workplace Relations Act with two key changes: an explicit requirement that applicants make reference to comparators through their application, and it excluded the Commission from hearing applications if the effect of the order would be to vary a minimum pay rate set under Division 2 of Part 7 of the Act. So we come then, of course, to a number of the issues that were raised by the inquiries in state jurisdictions, most notably New South Wales and Queensland. And again, it was the absence of significant progress in equal remuneration regulation, including the lack of any successful equal remuneration orders under the then federal jurisdiction, which led to, and the plateau in gender pay equity ratios, that sponsored the inquiries in New South Wales and Queensland. They were, of course, the inquiries held a great deal of evidence in both instances, most notably in New South Wales. And these were integral to the introduction by each State Industrial Relations Commission of equal remuneration principles to facilitate the making of pay equity orders. These principles in turn became the basis of significant wage increases for feminised occupations in both jurisdictions. Now, key to those principles and the proceedings that went with them, that accompanied them, was their distinctive nature, noting, just as a side note, that in Queensland the principle was buttressed by some additional legislative amendments. So undervaluation rather than discrimination became the basis of claims for equal remuneration. So this was a claim, this was a term, even a discourse that emerged in these particular jurisdictions as a way of overcoming the frailties of the discrimination test and a way of ensuring that the object of equal remuneration was met. Within that understanding, there was no requirement for comparators, so applicants could make use of a broad range of comparators, but they were not a necessary precondition to an application or to the evidence that was brought before the Commission. And these, of course, these two issues, this issue of undervaluation, this issue of comparator, this issue of who constituted the comparator, whether there was a specific requirement by way of gender or by occupation, and the lack of such a requirement became, we would think, the distinctive features of these two principles. Gender undervaluation was not specifically defined in either principle. It perhaps had some more detail as to its emergence in the reported pay equity inquiry. But it was in the Queensland principle that there was a more explicit sense of what some of the dimensions or the indicators of undervaluation may be. And this of course has been the subject of consideration both in the SACS proceedings and more recently in the childcare proceedings. And so these indicators went to a sense of factors that went to the work value and how work may be undervalued, such as work being characterised as female or feminised, whether there was evidence that the skills had been undervalued, a sense of segregation, over-representation of women in lower paid areas of employment, the sense of the terms of work, part-time and casual, low rates of unionisation and other industrial labour market features of the work. So it was these indicators of undervaluation which were initially mentioned in part in the pay equity report of the New South Wales inquiry that were explicitly identified in the Queensland principle. And it was these matters, of course, and specifically the issues arising from the community services case in Queensland that would later give rise to federal proceedings in the SACS case. But prior to that time, we think it useful to go to their work.
Thanks, Meg. So picking up the story with the Fair Work legislation, if we ask where had we got to with equal pay in 2009, well, there's one very clear baseline established 50 years earlier by the Arbitration Commission of equal pay for equal work. It's the one thing that had become utterly clear in our wage fixing system that we didn't, as we used to do under the old arbitration system, we didn't set different minimum rates of pay for work performed by male workers or female workers if we're talking about the same work. What had also become accepted as a principle was equal pay for work of equal value. But in the federal arena, the acceptance of that principle had had relatively little effect, and certainly the legislation introduced to allow what was then the Industrial Relations Commission to make equal remuneration orders in 1993 had simply failed to produce any results over the course of the ensuing 16 years. By contrast, at the state level, as you've heard, inquiries in New South Wales and Queensland had demonstrated an acceptance of a significant level of gender-based undervaluation of women's work in a number of industries and occupations. And that had not just been recognised as a matter of principle, but had been remedied in a number of cases, including, and importantly, as we'll see in a minute, in the social and community services sector. So against that background, we have the new provisions in Part 2.7 of the Fair Work Act. Now, it's fair to say that when the Fair Work Act was introduced, this was not a part of the legislation that attracted a lot of attention at the time. I think that's fair to say during both the drafting process and the process of parliamentary scrutiny in 2008-2009 when this legislation was going through. A feature I think you could fairly say it shares with the general protections. The importance and the potential application of this part of the legislation, along with the general protections, has really only become apparent as it started to be tested. But a number of things were quite clear. First of all, the severance of the link in the new provisions with the ILO's Equal Pay Convention and with the formula that said we determine a lack of equal remuneration by looking for an absence of sex discrimination, or as Meg has put it, in a more positive sense, you don't have to show discrimination in order to obtain an equal remuneration order. quite clearly too, we're not just talking about work of equal value, but work of equal or comparable value. It's clearly intended to broaden the jurisdiction. What's also clear from the legislation, later confirmed by Fair Work Australia in the SACS case, is that the power to remedy a lack of equal remuneration for male and female workers is a discretionary one, although the scope of the discretion is something that's being challenged in the current childcare case. I'll come to that in a little while. Importantly too, the power to make equal remuneration orders under the Fair Work Act is kept entirely distinct. It's in a different part of the legislation from the part that deals with the setting of minimum standards, in particular the award system. It's clear under the legislation that the power to make equal remuneration orders is not constrained by the modern awards objective, it's not constrained by the minimum wage objective. Those objectives are in different parts of the legislation. It is to be exercised by reference to the general objects of the statute, but importantly too, the legislation makes it clear that if the Commission grants an equal remuneration order, that prevails over any award or enterprise agreement that would otherwise apply. Clear evidence, therefore, of the parliamentary intent that the Commission has the power, at least, to regulate not just minimum wages, but actual wages, including overaward wages. And important to note too that this is a power expressed not by reference to pay or wages, but remuneration, so that, at least as a matter of principle, these orders can go to something more than the wage components of a person's remuneration or a group's remuneration. What was always going to be important was how the power was exercised, and it became very clear very quickly that there was going to be a test case in the social and community services sector. The ink was scarcely dry on the legislation when this application was being put together. It's an application brought by a number of unions, but led by the ASU, to, in effect, translate a successful case that had already been run under the Queensland legislation into the federal sector. Because of the limitations of the operation of state industrial laws after the work choices legislation, the Queensland case that was run only applied to employers in Queensland that were not trading corporations. Therefore, the actual impact of the Queensland pay equity order was relatively narrow. This was an attempt essentially to broaden it so that it applied not just to everyone else in the SACS sector in Queensland, but indeed to apply it nationally. It was an application that was supported by the federal government, at least to the extent that the Commonwealth was prepared initially to help to fund the application, to help fund research that would support the application. And the Commonwealth initially expressed a willingness to at least consider providing the funding that would clearly be necessary if many employers in this industry, a great majority of whom are delivering government-funded programs, would be able to afford to accommodate any wage increases that were secured. Later on, as we'll see, and I'll come back to this, that extended to a commitment to actually supply funding, indeed $2 billion worth of funding to help pay for wage increases. So this was the first test of Part 2.7. There were three main decisions in the case, and I'll quickly summarise them and then we'll come back and look at some particular features. First decision was handed down in May 2011 and to all outward appearance a unanimous decision of the full bench. I'll come back to that point shortly. It indicated that the full bench was satisfied that the what one might call the first prerequisite for the making of an equal remuneration order had been met. That is, the full bench was satisfied that there was not equal remuneration for male and female workers. However, the bench said that it wanted further submissions about the extent to which undervaluation of work in the industry, which it was satisfied existed, was based on gender. And that then flowed into the requirement to establish how much of the undervaluation was based on gender so as to justify a proposed remedy, that is, a proposed set of wage increases. Commission also rejected a call from many parties, including the applicants and the Commonwealth, and a number of, but though certainly not all, employer groups, to articulate a set of equal remuneration principles to guide both this and future cases brought under Part 2.7. Second decision, February 2012, saw the bench split. The majority of the bench was satisfied that the tasks set by decision number 1 had been met by the applicants, and I'll look in a minute at how the applicants went about doing that. They were satisfied that the lack of equal remuneration should be remedied broadly as proposed in a joint submission put forward by the ASU and Commonwealth. Vice President Watson, however, dissented. He would have denied any remedy on the basis that the requirements for making an order had not been satisfied. Again, we'll come back to some of the detail there. Third decision set out proposed increases. This might have been achieved by simply adjusting the award rates themselves, but the bench chose not to do that. They issued what is technically a separate equal remuneration order that simply prevails over the Social Community Home Care and Disability Services Industry Award for certainly not every classification, but for many of the classifications in that award, there were increases of up to or between 19 and 41%, plus a further 4% loading, and this reflects something that had become a feature of decisions, particularly in Queensland, a further loading to reflect a limited prospect of the workers concerned or their unions being able to achieve higher rates than the new minimum through enterprise bargaining. Importantly, however, and broadly as proposed in the joint submission, these increases were to be phased in over a very lengthy period, but importantly too, funded in significant part by the Commonwealth. Okay, so let's come back to some of the key elements of Decision 1. First of all, the full bench accepted two propositions which I think it's fair to say were uncontestable. That the decision to grant equal remuneration orders is a discretionary one. The legislation says an order may be made, it doesn't say it must be made. And they also accepted that the test for determining a basis for making an order had been broadened compared to the previous legislation, and in particular there was no longer a requirement to establish that rates had been set on a discriminatory basis. Then third, they accepted, and this becomes in many ways the key point of the decision, and as we'll see in a minute, the key point of contest in the current childcare test case, they accepted that there was no need for applications to rest on a male comparator. In other words, it was accepted, and I'll show you the quote in a minute, that there is no need to show that there is a lack of equal remuneration for this group of female workers compared with that group of male workers. At the same time, however, the full bench was very reluctant to accept some elements, at least, of the approach that had been adopted in the New South Wales and Queensland tribunals. They expressed concern about the idea of having marker points or indicators of undervaluation, those indicators which you saw earlier in Meg's part of the presentation. And they also made it clear, much I think to the dismay of the applicants, that it was essentially not enough to come and rerun the successful Queensland case. I think there had been a hope, which at one stage might have been quite a reasonable hope on the part of the applicants that if they'd won the case in Queensland and if they'd introduced all this evidence, and much of the evidence went back to evidence that had been adduced to and accepted by the pay equity inquiries in New South Wales and Queensland, if they simply ran the same case again and said, well, this, Queensland's already accepted this, New South Wales has already accepted this as a matter of general principle, the federal tribunal should as well. It was clear that any hope of that was dashed by this first decision. Let's have a look at some of the key points. Here's what the full bench said about the need for a comparator. So you see that the existence of a valid male comparator group which receives higher remuneration than a female-dominated group is one way of demonstrating the need for an equal remuneration order. We do not accept that as a matter of logic, it's the only way. Presence of a male comparator group might make the applicant's task easier, in the absence, more difficult. But it doesn't follow that in the absence of a male comparator group, the application must inevitably fail. That, I would argue, is the single most important point that emerges from the SACS decision, and it's the point that the full bench of the Fair Work Commission, currently hearing the childcare case, as we'll see in a minute, is being asked to reconsider. This is another quote from the full bench doubting the value of the indicia approach. Even if all the indicia are present, doesn't necessarily follow that gender-based undervaluation exists. Converse, also the case. The list of indicia is no more than a framework for considering whether there is undervaluation. I think it's fair to say that the full bench in this decision accepts that undervaluation is an appropriate way to approach the task, or at least one appropriate way of approaching the task of determining a lack of equal remuneration. But clearly it's not enough simply to tick off the indicia formulated in the Queensland principle, say, well, those are present in this industry, therefore there is undervaluation based on gender, therefore there must be a remedy. So why did they find there was undervaluation based on gender in the SACS industry? Well, the key point here, and this becomes essential to the way the applicant's claim is then framed and succeeds, is on the basis that much of the work in the industry is caring work. And that last point, because caring work in this context has a female characterisation, to the extent that work in the industry is undervalued because it is caring work, the undervaluation is gender-based. So we see a series of propositions accepted. Work in this industry is caring work. Work in this industry has been undervalued. Because that work is caring work and it's undervalued, we're satisfied there is undervaluation based on gender. Join the dots, neat little logical progression there. And then this becomes the key to the split in the next decision. Although work value change is not irrelevant under Part 2.7, it's clear that equal remuneration provisions are directed not at undervaluation itself, but at undervaluation which is gender-based. So remember, the full bench has accepted there is gender-based undervaluation, but it now wants to know, for the purpose of the second decision, how much of the undervaluation, exactly how much of the undervaluation, is based on gender rather than based on some other kind of undervaluation. And here's the refusal to set an equal remuneration principle, essentially on the basis that it would be premature to do so. This decision will constitute a significant precedent in any event. Or as it turns out, perhaps not so much, for reasons that I'll come back to shortly. Okay, so what did the applicants then do in responding to the submission? First of all, they put forward evidence to support the idea that there is an unexplained gender pay gap. So this is the analysis that tries to screen out all the factors that Meg mentioned earlier, different jobs done by men and women, different education, etc., to say there is an unexplained gender gap. And then they used, the crucial point was to seize on the findings about caring work and to use caring work as a proxy for gender-based undervaluation. So they commissioned research which said this much of the work done by the relevant workers in the sector is caring work. This is the wage that compares, of these workers compared to similar work being done largely in the public sector. We get a dollar value for the difference between the two groups and then multiply that dollar value by the percentage of the work that is caring work, and that tells us how much is the gender-based undervaluation, and we then calculate the wage increases that are needed to remedy that. The majority in the second decision weren't prepared to accept that there should simply be a straight comparison between SACS rates and work performed by similar kinds of workers in local and state governments. Again, they accepted that gender was an influence, but the gap was not entirely attributable to gender. They expressed some reservations about the way the joint submission had gone about this, but essentially, at the end of the day, they felt that the approach proposed in the joint submission was good enough and had satisfied the majority that an order should be made. Why didn't Vice President Watson agree? He didn't like the idea of using the public sector as an equal remuneration comparator because he felt there were other reasons why you would expect differences between non-government and government sector wages. He felt that there'd been a failure to demonstrate the undervaluation was gender-based, and there's clearly he was concerned about the lack of a male comparator, because you see most of the relevant comparator workers here in the state and government sector are female workers. And thirdly, he was concerned that making this order would effectively remove any incentive to engage in enterprise bargaining in the SACS sector. Whoops. Okay, so here's his point on the issue of comparison. He said this is essentially the wrong comparison. It's hard to square this with what was said in the first decision. Here's a much lengthier quote about which looks at, among other things, he looked at the way that equal pay claims have been addressed in other countries around the world, and he said what those other countries show is that you're supposed to find a reliable benchmark or comparator. He said that hadn't happened here. Basically what he's arguing is that the applicants simply haven't demonstrated, haven't explained away all the other possible explanations for gaps in the wages being paid for this work in the SACS sector and broadly similar work in state and local government. So how do we assess the SACS decisions? Well, SACS decisions turn out to be not the precedent that we might have hoped, for two main reasons. Firstly, because, try and put this as tactfully as I can, but particularly given the presence of the person who headed that event in the audience, and indeed his successor, who's dealing with the next case that I'm going to talk about. So you can see I'm on relatively shaky ground here. It's quite clear from reading Decision 2 that there was a great deal of, that there was certainly a difference of opinion between members of the bench. And when you go back and look at Decision 1, it becomes apparent that Decision 1 is effectively a compromise decision between two very different views of this legislation. That difference of opinion then emerges clearly in Decision 2. One is left, therefore, to question whether parts of Decision 1 are really just compromises to try and hold the bench together. In saying this, I'm not intending in the slightest to be critical of any member of the bench, simply making an observation. It's difficult to know what that first decision might have looked like had the bench split at the first decision. The other point here, of course, was that by the time decision 2 was made, the Commonwealth was dangling $2 billion. And indeed, it was always clear from the outset of this case that the Commonwealth was favourably disposed towards the claim and was prepared to fund it. That must have had an impact. Certainly on some of the employers, many employer groups supported this claim, but potentially on the bench as well. What would happen in a case where you didn't have that? Well, we're about to find out. But nonetheless, of course, the case is still very useful because it demonstrated the potential for a kind of pay equity claim that you don't tend to find in other countries. And you don't tend to find in other countries because they don't have the same apparatus and history as we do of setting wages on an industry or occupational basis. And also because the decision exposed different approaches. Well, those differences are now being played out in the next big case, and this is being brought for childcare workers. It's important to note that the Pay Equity Unit of the Fair Work Commission has played a very interesting and supportive role, firstly by commissioning our research report, and so we're very grateful we had the opportunity to do that, but also by compiling, after a lot of consultation with parties involved in the case, data that could usefully be used in the case. Significantly, however, the Commission has sought in this proceeding to do something that it refused to do in the SACS case, and that is to have a preliminary phase in which the parties argue out the interpretation of the legislation. The Commission has sought submissions on what it calls the legislative and conceptual framework relevant to the conduct of the proceeding. And those submissions, the arguments about them, make fascinating reading. We're expecting a decision fairly soon from the bench to rule on that framework, and that will tease out some of the continuing contests about the meaning and potential application of Part 2.7. So with that in mind, I'm going to hand back over to Meg to talk about some of the possible ways forward and uncertainties about what might happen.
So here we stand with the invitation by the current full bench to address the legislative and conceptual framework. We revisit some of the issues that were dealt with in New South Wales and Queensland and in part in the SACS proceedings. So there's consideration, of course, as to whether there should be an equal remuneration principle, something that would perhaps occupy the ground between uncertainty and prescription in the way which these matters are dealt with. And specifically in these proceedings, there's been a great deal of attention paid to whether there should be a limitation on the type of applications that are brought to the Commission, specifically whether applications should be confined to an enterprise nature, either inter or intra-enterprise nature of application-based application, and what new challenges are provided for the Commission on industry-based claim. Now this, of course, is a key feature in terms of Australian labour law because of the industry-based nature of awards. So this issue opens up the question of the scope of applications. Then we return to matters that were certainly aired in the SACS proceedings and in New South Wales and Queensland, and this is, of course, the type of evidence to be considered in any claim to gender-based undervaluation. And we revisit here the utility or otherwise of the type of indicators that are set out in the Queensland provision. That in turn invites a consideration of how applicants whether applicants should be or are required to isolate gender from a number of other factors that may constitute undervaluation, and whether indeed the Commission favours a particular type of empiricism in this approach. We note, as Andrew did just recently, that in the ASU in the joint submission in the SACS proceedings was able to use a proxy methodology along with a particular analysis of public sector rates But whether this methodology is available to other applicants, of course, is a more confronting question. And whether it's appropriate and whether we're able to isolate gender from other reinforcing factors in undervaluation remains a vexed question. Of course, the issue of then any preferred approach to the demonstration of gender-based undervaluation raises with it the question of the utility or the requirement for, explicit requirement for comparator-based assessments. And as Andrew has noted, this issue about whether an explicit requirement for comparator-based assessments makes for very interesting reading in the current submissions, particularly whether it's a requirement for a binary comparator assessment between female and male or feminised and masculinised areas of work. The last three items are matters that have been, I guess, more germane to the federal jurisdiction, although the issue, the relationship of gender-based undervaluation to work value claims did receive specific attention in the New South Wales Pay Equity Inquiry. This sort of sense about the way you can perhaps potentially isolate, or whether it's possible to isolate gender-based undervaluation from an explicit work value claim. And the last two items are particular to the current federal jurisdiction, and that is the relationship of Part 2.7 to the modern award and minimum wage objectives, and the Commission's obligations under Part 2.7 relative to those other parts of the Act and the overall objects of the Act. And then an interesting issue that has been raised by way of submission as to what we've termed here the all or nothing approach to remedy. And that is that if the Commission were to find that there were gender-based undervaluation, it was approximated that whether that remedy should be awarded in full. So it's a crude way of summarising this sense of all or nothing, and that also is connected, of course, to the Commission's discretionary power in this regard. Now, there is perhaps a number of choices open to the Commission, and we have cast them here as both a narrow and a broad approach. Clearly, there are some points in between. We conceive a narrow approach to the interpretation and application of Part 2.7 as one that would include a requirement for comparators, specifically a male benchmark or comparator. We think this rests on a narrow construction and interpretation of the legislation. In this scenario, there would also be an empirical requirement to establish and quantify the precise contribution of gender to any cited earnings disparities. So this is underlining, if you like, a form of empiricism in the demonstration of gender-based undervaluation. And again on this narrow construction, there would be a requirement to separate gender-based undervaluation from a broader dimension of work value that could be done. The application of Part 2.7 would be constrained so that it does not allow for the revaluing of work where rates have already been set by the modern award. So, in a sense, it holds the rates in the awards as being properly set and representing appropriately the value of the work. And Part 2.7 would not be utilised to remove the incentive for enterprise bargaining. And you will recall that this was a clear concern of Vice President Watson in his dissenting judgment. So that, we note, is a particularly narrow approach of Part 2.7 and has been illustrated in a number of the submissions in the current proceedings. We've identified a broader and, we think, a preferable approach, is one where there is no limitation on the type of claims that come before the Commission. Clearly there could be claims that would rest on some claim involving a number of enterprises, intra-enterprise or within enterprise claims, as well as inter-industry claims here. So clearly with the inter-industry claims, one that is founded on an equal remuneration order that would apply to an award. Comparators would be permitted but are not required, and I guess this would rest on an understanding here that the requirement for comparison is not necessarily capable of revealing the full extent of gender-based undervaluation, that a comparison in and of itself will not necessarily reveal all of the components of that undervaluation, particularly because of the cumulative and additive nature of undervaluation as we currently understand it. Specifically also, there would not be a requirement for the comparators to rest on a binary gender-based formulation such that you would be comparing explicitly feminised and masculinised work. We sense here that this brings with it the understanding that carries forward from the New South Wales and Queensland proceedings, and also that part of the SACS proceedings that indicated that there was not the requirement for a comparator of this particular nature. The framework would permit consideration of factors other than gender, noting here and taking account of the research that indicates the difficulty of separating gender from a number of other factors that inform undervaluation. And I guess this goes to the layered and interconnected nature of the factors that comprise undervaluation. So clearly in those two scenarios, as painted, narrow and broad, there are medium points in between. But this material takes on board, this broad approach takes on board the casting, I guess the understanding, the sense of whether the object of equal remuneration for work of equal value for women workers can necessarily be met by strict binary comparison. This, of course, lies at the centre of the material initially considered in New South Wales and considered again in Queensland, considered again in SACS, and considered now in the childcare proceedings. Which leads us to our conclusion, I think. No, I don't know.
Okay.
Yeah.
So just to finish up, it's perfectly reasonable to have different views about the gender pay gap. But at the end of the day, we're persuaded by what we think is the weight of academic research and evidence, which says the gender pay gap is not a statistical blip. It reflects a degree of undervaluation of work typically or often performed by women in our labour market. Part 2.7 provides a very powerful tool that allows that undervaluation to be remedied if it's interpreted as broadly as its terms permit. What we've sketched out is two approaches, both of which we think are permissible interpretations of the legislation. We're not suggesting there is a right and wrong answer here. I think there's a permissible interpretation of the legislation which essentially robs Part 2.7 of almost all power to make a difference to pay equity, and an equally permissible and we would say preferable interpretation that would allow the Commission at least the opportunity or the power to redress a lack of pay equity if a properly evidenced case is brought for a particular group or sector. Now, what we also concede is that the discretionary nature of the remedy, or discretionary nature of the Commission's power in this area, means that it is perfectly plausible that the Commission could find, for example in the childcare case, I don't want to open a book on the result of that case, I should say. But it would be perfectly plausible for the Commission to find that there is the basis for the making of equal remuneration orders, but that those orders should not be made purely on the basis of their adverse economic or social impact. This is a difficult area, particularly when you're talking about a claim for substantial pay increases that affect a large number of workers in areas where the businesses concerned are reliant on government funding. But in our view, whatever the outcome in the childcare case or future cases, we hope that the Commission will choose the broad approach. And we hope that it will send a message that Part 2.7 does provide a basis for addressing the ongoing issue, the lack of gender pay equity in Australia. Thank you.